Well, welcome everyone. Glad to see you this morning. I'm Heather Gessner with IFTN based out of South Dakota State University in Sioux Falls. Glad to have everyone that was able to make it today. And we've got a great presentation and conversation for you today. So I'm going to just open it up a little bit and remind you that you're here for the Uniform Partition of Heirs Property Act, which really affects a lot of our African American landowners, predominantly in the South, but also other parts of the nation as well. Those of us living in the Midwest, we've got our Native American communities on reservations. Then there's tons of other effects and factors where this comes into play. And it can also be one of those unintended consequences as many of our farms and ranches start to make their estate plans and their property distributions. So as we look through this conversation today, Francine Miller, she's a senior staff attorney with the Center for Agricultural and Food Systems out of Vermont, is going to lead our panel. So I am not going to take much of this presentation over. I'm going to turn it over to Fran. She can introduce herself, introduce the members of the team that are going to be on the panel today, and we will go from there. So, Fran, why don't you take it away? And I'm looking forward to a great presentation today.
Thank you so much, Heather. Well, welcome everybody. It's great to be here with you all and with this esteemed panel. As Heather mentioned, today we're going to talk about heirs property and the Uniform Partition of Heirs Property Act, which is definitely a mouthful. So I will probably just call it the Uniform Act. This is state legislation that's been enacted in 24 states that addresses some of the abuses that have occurred to families owning property as heirs property. But before we get into it, I'm so glad that Heather asked you to put your state and your familiarity with the information. It sounds like there's a pretty wide range, but maybe we'll just do some basics of what is heirs property and what is the act. First, I just wanted to introduce myself. As Heather said, I work at the Center for Agriculture and Food Systems at Vermont Law School. I'm an attorney. I've been working on these kinds of issues for about 5 years. And I just want to acknowledge that although there is much more attention being paid to this issue now, people like Karama Neal on this panel, who I'll introduce in a little bit, have been working on this issue for decades. And many of us newer to the issue really stand on their shoulders. So thank you, Karama. So with me here today, you can see in the Brady Bunch screen, there are 3 women who've been instrumental in this work in different ways. I'm eager to introduce them to you. So Karama, who I mentioned, was instrumental in passing the Uniform Act in Arkansas. And what I'm going to do is say just a sentence about each of these folks, and then they're going to introduce themselves more fully. They each have a much bigger resume than we are able to do here, but relative to heirs property work, we'll talk about that. And then J.C. Fisher is an attorney in Alabama whose practice is really predominantly devoted to preventing and resolving heirs property. And finally, Jane Sternecki is an attorney at the Uniform Laws Commission, and she is focused on the passage of the Uniform Act across the country. And so we'll hear much more from them. I'm going to ask them to introduce themselves. I'm going to ask some general questions, and then we're going to open it up to questions from you all. But I just want to make sure that everybody has a basic understanding of heirs property and say a little bit about the act. Before I get into that, I have to make a plug for a toolkit that I work on at the law school, at Vermont Law School, and that is relevant to y'all's work. And it includes information about heirs property. It's called the Farmland Access Legal Toolkit, and I will put the link in the chat once I stop talking. It includes resources for farmers and for those providing technical assistance to farmers all about land access, leasing, conservation easements, accessing land more affordably, succession planning. So please check it out after the webinar. All right, so let me talk a little bit about heirs property in the Uniform Act and then get to these fabulous women. So heirs property is sometimes known as family land, inherited land. It really depends where you're from. In Pennsylvania, a lot of people call it tangled title. It is both urban and rural, although we are probably primarily focusing on rural here. It is property that has been transferred to multiple family members by inheritance, usually without a will, but not always. Typically, it's created when land is transferred from someone who dies without a will to that person's spouse, children, other heirs who have a legal right to the property. But it's really important to know, and I say this with JC right there, who knocks my head about this issue, that even if the person who died had a will, and Heather mentioned this too, they could still create heirs property if they leave the property to multiple heirs without specifying which heirs get what specific piece of the land or property. So when heirs property is created, heirs own all the property together. In legal terms, that's called tenants in common. They each own an interest in the whole land rather than each heir owning an individual lot or piece of the land. And really importantly, unless the heirs go to probate court or whatever the appropriate administrative agency is in their jurisdiction and have the title or the deed changed to reflect the new ownership, the land remains in the name of the person who died. And for the heirs, owning property in this way as tenants in common without clear title just leads to a lot of challenges. It's a very vulnerable way of holding land. A few things about that, because it's difficult to prove ownership because their names are not on the deed. They probably can't access loans or mortgages. They often cannot apply for USDA grants or loans. It's very difficult to build wealth from the land by engaging in any commercial activity, selling timber or other resources, all of which most often require proof of ownership. And what we're going to talk about here, it leaves the property vulnerable to being acquired by real estate developers and other unscrupulous actors, we'll call them, through what's known as a partition action. So really briefly, because the panel's going to talk much more about this, any of the tenants in common as co-owners can bring a lawsuit in court for what's called a partition of the property, so that that specific shareholder, co-owner, can get the value of their interest in the land, in the property. And this has led to significant land loss for heirs property owners, as real estate speculators or other unscrupulous actors can buy an unsuspecting co-owner's share for a small amount of money. Somebody needs a few $1,000s and somebody approaches them and says, hey, I'll buy your share. And they don't know what can happen, which often is, or can be, that person goes to court, brings a partition action, and asks the court to sell the whole property so that they can get the value of their share. And this has often resulted in a court ordering such a sale, and used to always result in an auction of the property on the courtroom steps at much less than fair market value. And maybe the real estate speculator has a buddy doing some of the bidding at the auction. We'll talk more about this, as this is where the act comes in, the Uniform Act. Really briefly, it restructures the way these actions occur, the partition's actions, and it gives heirs property owners protections that are really designed to allow them to keep property within the family wherever possible, or at least ensure that they receive fair market value if the property is sold. So I know that's a lot of information and I hope it's clear, but please put any questions in the chat and we'll get into it with the panelists who I think will be able to clarify things. So without further ado, Let each of you introduce yourselves briefly and say the kind of work that you have been doing on heirs property, and then we'll get into some questions. Okay. Karama, would you start us off?
Sure, happy to start. So really pleased to see all of you here. Thanks so much for your interest in this really important topic. I know I represent the non-legal component of this panel. So I'm not an attorney. What I am is as a property owner. So my great-great-grandfather bought property in Southwest Arkansas just after he got out of enslavement. And that property has remained in our family all these years and is heirs property. And so I've grown up knowing this. I've grown up seeing my grandmother and others, collect money for the taxes and make sure it gets paid and doing all those kinds of things. And now that I am actually an heir to the property, I was very excited to get started and try to figure out how we could make best use of this property that we have, this asset that's been passed down for so many years. And as a non-attorney, I went out and started trying to find all my cousins and all my relatives and get together and figure out how to do the family tree. And we were going to do all these things. My father, though, is an attorney. It's not my father's property, but he is an attorney. And he advised me, he said, Karama, you may not want to do that. You may find the wrong cousin. When he said wrong cousin, he meant exactly the kind of thing that Francine was just talking about, right? The cousin who sees dollar signs potentially, maybe is not particularly invested sentimentally or otherwise in the property and wants to get dollars for it, right? And so he raised concerns that I probably didn't need to do that. And so I felt stuck. And so as part of that, because I felt stuck, I was literally looking online for things that a family could do when you're in this situation. I felt like I couldn't find the relatives and try to clear the title that way because I might find, quote, the wrong cousin. And so I didn't know what to do. And I literally stumbled upon the Uniform Partition of Heirs Property Act. And then in 2013, late that year, started a statewide grassroots organization in the state of Arkansas to get that passed. With the support of the Uniform Law Commissioners in the state of Arkansas, eventually and then the support of the Arkansas Bar Association, we were able to get that passed in 2015. Since that time, we have frankly worked defense. Thank you. Frankly, worked defense because there was some efforts to get it passed, to get it repealed. After that, Arkansas was the 5th state in the country to get it passed. So we were fairly early on. So it may be a little bit of a different environment now. So work that defense. Thankfully, the act is still in place. And since then, I've worked in doing research and writing and education around heirs property, and most recently have become a certified mediator so that I can help provide mediation services to families who are not in alignment on how they want to use their property and want to become in alignment. So again, they can make that property the strongest asset it can be for themselves and their family. So I'll stop there, but very excited to be here and share more and make sure that folks know more about this important issue. Thank you.
Thank you, Karama. JC, why don't you go ahead?
Yeah, good morning, everybody, at least on the Central Standard Time. My name's JC Fisher. I'm a senior associate attorney at Greg Varner and Associates. We have 2 offices, one in Birmingham and then one in East Alabama in Ashland in the hills. We basically serve underserved communities. That's our mission, is to provide high quality legal services to underserved communities. But we are a private practice firm, so we're not a pro bono firm, but we do a lot of low bono work. And so my practice is primarily focused on heirs property and clearing title, but also all of the associated issues that come with heirs property. And that would be, landlocked, people who are landlocked from public road access, adverse possession, tax sale issues. I pretty much deal with all things surrounding underserved communities almost losing their land in any type of way possible. So I've been doing heirs property specifically for about 5 years. And it's been an interesting ride. I would say my expertise at this point is in partition litigation under the UPHPA, the Uniform Act. So we have had the Uniform Act since 2014. Technically, it was in effect 2015. But when I started taking UPHPA cases in the state of Alabama, nobody knew that the act existed. So the judges didn't know, the real estate attorneys that have been practicing for 30 years didn't know. And so it's been within the last 3 years that Alabama has actually begun using the act, which is sad because we've had it for almost 10. And so I'm sure that there was a lot of property lost mistakenly under the old statute before we started widely using it. So anyway, that's kind of a little bit about me, and I'm looking forward to discussing more.
Great. Thank you, JC. Jane?
Yeah. Hi, my name is Jane Sternicki. I'm legislative counsel for the Uniform Law Commission. So I work on enactment of the act, as Fran very accurately mentioned. So what that means is I work with the Uniform Law Commission's commissioners. So we have commissioners in all 50 states and the 3 U.S. territories. They're appointed generally by the governor of each state to come together to draft uniform laws. So they were the basis for the creation of the Uniform Partition of Heirs Property Act, which was drafted by Professor Thomas Mitchell. He was the primary drafter. This is getting a little bit into what will be our first question, Fran, I think, but just to give you background on the ULC and the work. So my colleagues and I work on enactment. So we're a team of attorneys who have divided up the ULC's act into different practice areas. I work specifically on real property acts. So the UPHPA is a big piece of that, probably the biggest piece of my portfolio. So we work with commissioners in each state to get the act on the radar of legislators, and then we try to do coalition building with our various groups from each state. Obviously, those coalitions end up being a little bit different in each state, but we certainly have some folks who are reliably with us through every step. So that's my experience with it. So I work on providing testimony, coordinating those coalitions, getting stories together from people on the ground, people like Karama who've been directly affected by issues with this act, and then continue to do what we can to try to get it passed in as many states.
Great. Thank you so much. So each person on the panel has different expertise relative to this, and I think maybe it would be helpful to start with Karama, actually, to talk a little bit about the work that you did to get the act passed in Arkansas. Looking at who's on the call, obviously in some states it has been passed, and we can talk about what the impact has been. JC can talk to that issue, and Jane obviously can talk about how ULC can support folks who are interested in advocating for this. But I think it would be helpful to hear an example of how this worked on the state level and what you all did.
Yeah, thank you so much again for this opportunity. It was really, in a lot of ways, sort of an organic process. As I said, literally was a Google search, and late at night just trying to find what those options might be. And it was clear when I read the summary of the Uniform Act at that point that the materials that the Uniform Laws Commission provides are great. I actually just put the link to the UPHPA site at the Uniform Laws Commission in the chat for folks who might be interested there. Really, really useful materials, right? And so literally was just reading that information. And I really encourage folks, if you don't have familiarity with the act, to read it. It's actually pretty interesting, right? So it's a lot of legalese for those of us who are not attorneys. But I think what Professor Mitchell did very well was put in context for why certain kinds of features are included in the act. Historical rationale, current rationale for why these kinds of things are needed, what the impact would be if they're there, what the impact has been because they've not been there in the past. So it's really actually a really good read. And so I was reading that information and recognized that if we were able to get this legislation passed in Arkansas, it would help families like mine. I knew there were lots of other families like mine as well. A few things that I would highlight in thinking about that. I mean, this was, one is the role of thinking about landowners in this work. It is, we're an important constituent group, right? And so, we're the ones who are affected. And I think that we can really oftentimes speak and advocate very clearly for why it is we need this work, we need this done. One of the things that was important, given the state that I'm in, the state that our property is in, is to think really intentionally about how we communicate about heirs property. I shared when I opened here why my family has heirs property. That was not how I led in the conversations about this work when I talked about it here in the state, right? Depended on the audience, honestly. And so it was very, very intentional to build as broad a net as possible in thinking about who has this kind of land. I think certainly among rural Black Southerners, heir property, which, and I specifically did not use the S there because that's not what I called it growing up. It's not what anybody I know calls it. But heir property is something that is a lot of people have lots of familiarity with, even if they don't have it themselves. It's a common thing. What I've found is that many other populations have heirs property, but don't call it that, right? And so that terminology is not familiar to them. And so in terms of building support for the act, part of what was important was to create a broad tent and talk about it in ways that people could see themselves in the work that we're doing. And I definitely saw instances of that many times as you know, we do the work and I'd share what I was doing and people would tell their story and I'd say, look, you actually are in the same situation, right? You may not call it what I call it, but you're in the same situation and there's a reason for you to be supportive of this as well. So that strategic kind of communications, also thinking, you know, strategically about the approach to how you position the legislation. We were very fortunate, as I said, as I started this work, that the Uniform Laws Commission recognized that there was this sort of, you know, nascent effort building in the state, grassroots effort, and the Uniform Laws Commission commissioners in the state were very supportive of this work, and so they reached out fairly early on and were very supportive of, you know, trying to figure out how they could help support the effort to get it passed. Because they are part of the Arkansas Bar Association. They're attorneys, of course, I'm not. They were able to get the Bar Association to put it on their legislative agenda. And that was really a strategic piece too. And again, I say these things because depending on the state that you're in, depending on where it is you're working, depending on the political climate and other kinds of things, these are the kinds of things one needs to be thoughtful about. It's not a copy and paste job, right? But it is a consider these kinds of options and what makes sense in the place that you are. In the place that we were, it was fantastic that the Bar Association got involved and they were able to present this as, frankly, simply a legal issue that the lawyers understand. Y'all probably don't need to worry too much about it. Get this thing passed and it will have, you know, it's meaningful for the attorneys. That is absolutely true. It's also meaningful for lots and lots of people. And so we were able to get that passed. As I said, we did have to play a little bit of defense. There were some efforts to repeal portions of it going forward. And again, I think that's where it was really important to think strategically about communications and how we talked about it. Heirs property is often talked about as a rural Southern Black problem. And I contend that in many cases, it is none of those. Even if there are problematic aspects to heirs property, which there certainly are, right? This would need to act if there were not problematic aspects. Inherently, it is an asset. Inherently, it is an opportunity. Families wouldn't be trying to hang on to this property if they didn't see it as something positive in their lives, something positive they wanted to hang on to, that they wanted to keep and retain. And so I think, and again, it's not always, we heard earlier, it's not always rural, it's certainly not always Black, it's not always a Southern. We see heirs property across the country in all population groups. It is inherent, there's a prevalence in low income and low wealth communities that have not had access to strong legal services that they could trust, that they could afford. So you definitely do see a preponderance in communities of color and low wealth communities, but that's not the only place it exists. And I think, you know, in as much as heirs property exists, I think part of what I would hope all of our work is here to do is that it may exist, but can we keep it from persisting, right? So, you know, if someone passes without a will and they've created heirs property, that's fine if it lasts for a couple months while you go through probate, right? What's not fine and not ideal is if it lasts for, you know, 10 years, 50 years, 150 years. And so I appreciate, again, folks' efforts to think through this. And I would just say, as you're thinking about, especially if you're looking at passage in your state, and we can talk about if you've already had it passed, what some other kinds of options may be. But if you're looking at passage, really think about what's going to fly in your state, what's going to be acceptable, what folks are going to hear in your state. It's going to be different in different places. And I think it's just an important thing to consider to ensure success.
Thank you, Karama. Yeah, I have a lawyer friend who is a farmer in Missouri whose dad died recently and whose dad and his sister, so his aunt and the dad, own the property jointly as tenants in common because their parents didn't have a will. So now now the dad's died. And so the aunt and my friend and his 3 siblings now own the property, and they're fighting because it's in a place where there's a lot of development and he wants to farm and they want to sell. And this is the kind of thing that happens to all kinds of families.
It is. And I'll just say really quickly, since you brought up Missouri, it's a place, again, where they were very strategic. In Missouri, my understanding is the Heirs Property Act there is called the Save the Family Farms Act, right? So
Yeah.
again, being very strategic about what is going to resonate with the people who are going to be voting on this in whatever state it is. So I appreciate that you raised that example for the reasons you described, but also because it is an example of how folks have been very strategic around what is going to resonate with the legislators.
Yep. JC, can you talk a little bit to how these issues play out in Alabama in your experience? And also, having attended a conversation that you just led recently about will drafting to avoid heirs property. And these are these folks who we're talking to do a lot of farm transition advice and counsel. I think it might be helpful to talk a little bit about that as well.
Yeah, absolutely. So as it relates to the UPHPA, the Uniform Act, it's been a journey in this short time. Right now, we probably have 3 litigators in the whole state that handle UPHPA defense. And so two of them are me and my coworker. And so we are all counties in the state taking on UPHPA cases. One thing that's interesting is that the Uniform Act, there's kind of an incentive for attorneys not to defend against partition actions because the Uniform Act does allow for, at least here in Alabama, it still allows for the plaintiff's attorney or the attorney ensuring that the sale occurs to receive 10 to 15% of the sale proceeds if they are appointed the commissioner. And the case law allows for up to 15%. So there is obviously an incentive for people to bring these attorneys to bring these partition actions. And so that's one of the issues we're running into in Alabama with getting attorneys to do this work on the defensive side is there's, you ain't making no money off heirs property law. So, but you can make money if you make sure it's sold. And so that's been an interesting challenge here. But I do want to talk about some of the significant impacts and protections that it has had. I just had a case yesterday that we finished up after only 13 months, which is a short time for a UPHPA case to happen, where my client was able to successfully do a buyout of only those heirs who wanted to sell. And so one major impact that the UPHPA has made is that in our old statute, the buyer, so the heir that wanted to buy out the others, they had to pay the full purchase price for all of the property in order to purchase the land, and that included their interest. So whatever their interest was worth. The way the UPHPA works now is that you only have to pay for those who file and request a sale. So those who in writing say, I want a sale. Well, you got to imagine if you've got 80 heirs and only like 2 or 3 of them are probably represented by an attorney, the pro se ones or the ones who are not represented, they're not filing anything, to be frank. I mean, they're pretty silent. And so now, in order to keep the property, you only have to pay what the interest is worth of those who asked for a sale. That's a big difference. So for example, in the case I finished yesterday, he was supposed to pay $240,000 the day before I got into the case to buy all of the property. When I got into the case, I notified the judge that they were using the wrong statute, which is the case in every partition action I have, and that he only had to buy the interest of those who asked for a sale. Well, that was only $50,000. So the difference between $240,000 for a land-rich, cash-poor person and $50,000 is significantly different. And so he was able to successfully do the buyout. And the UPHPA says, once you do that buyout, the case shall be dismissed. And so the case is done at that point if there's no one else who indicated they wanted a sale. That's a huge difference for everybody. And so it's made a significant difference in cases like that. And I have many other cases that have ended just like that. I have other cases where my clients have come out with clear title because they've been able to buy out all of the heirs that all indicated they wanted to sell. And so they've been able to, number one, maintain the property in the family and save it from being sold to a third party. And number two, come out with clear title through the UPHPA. And so those are just like two examples. But I do really quickly want to talk about the Corinne Woodson case out of Auburn, Alabama. Some of you may have seen that in the news. It was a case in Lee County, so Auburn, Alabama, that fell under the old statute. And so we still have the old statute in Alabama. Okay, we have the new statute and we have the old statute. And so this was an 18-year-old case that I got in on the last year that it existed. And so in that case, my client did not have the protections of the UPHPA. It fell under the old statute. Well, she owned 40 acres, an 11% interest in 40 acres that she had lived on since she was 18 years old. She was 83 when she retained me. Her husband had built that house for her. She had lived on it her whole adult life. And these real estate investors got a 50% interest and, you know, filed for a partition. Well, the property the 40 acres that she thought was worth $300,000 was actually worth $3.97 million. So when she went to do the buyout, they expected that she was going to put up $3.97 million to perform the buyout because that's what the old statute required. The UPHPA would have said she only had to pay 50% of what that price would have been. And is that a steep price? Yes. But it turned out that we had an investor, a private anonymous investor that was willing to help her save the land. And so being under the UPHPA would have made a significant difference from the get-go. And so that's that. And then really quickly on the farm transition, because we did just do a training on how to prevent heirs property and wills. The one thing that you want to make sure you're doing is that if you're talking to people about estate planning and, you know, transitioning and succession plans, you want to make sure that you make it clear to them that it's not enough to just have a will, okay? In the Corinne Woodson case in Auburn, Alabama, that heir's property was created with a will. This man, during Jim Crow, got a will and left it to all his children in equal shares, which is what most of the wills look like. That's how we're taught to draft them in law school. So it's not enough to just get a will. You want to make sure that the will is drafted such that it prevents heirs property and that you put them in touch with attorneys who know how to prevent heirs property and develop and build your networks with people who are going to prevent that kind of language in the will.
Thank you, JC. There's a couple of questions in the chat. One question was in the examples that you gave where the person just bought out the people who brought the partition action. I think the answer is they don't own the whole property then. They just own their interest plus what they bought out.
That's correct. So it returns to heirs property, but it does get the case dismissed. And what y'all need to know is that sometimes that's the most important thing for the client. For the same reasons Karama just described earlier, it's not like staying as heirs property is not as bad as the property being sold to a third party. And so, yes, ideally that person would come out and own all of the property and have clear title to it. But these families want this litigation dismissed because if those buyout rounds fail or the judge doesn't give them a physical division of the property, we call that a partition in kind, that property is getting sold on the open market and worst case scenario at auction. So you want to get out of litigation as soon as possible.
Mm-hmm. Okay, great. So I want to talk a little bit about how the UPHPA is not a silver bullet, and we'll get there. But first, Jane, let's talk a little bit about how it works in the Uniform Law Commission and your role. And like if anybody on this call wanted to do some advocacy or education around the UPHP and get it passed where it's not passed, what do they do and how does it work with you all?
Yeah, so I mean, we're trying to target any state that doesn't already have it. So in that map that I posted in the chat, any state that is, I mean, even those green states, so those are states where we had an introduction in the past session, but where we were not ultimately successful in getting it passed. Michigan, we're hoping we'll end up passing it this session, but the remainder of those I think are still outstanding. So Stories of folks who have experienced issues with heirs property, stories from attorneys who have represented clients who are dealing with issues with heirs property, those are immensely helpful. It's very easy for legislators to kind of brush the issue under the rug when it's not right in front of their faces. And so when we can show, look, you have constituents who have personally dealt with this, or who have been, had their family land taken from them. Of course, those are very sad stories that we have to tell. And ideally, they're folks who we can say, these people are quite vulnerable now. Nothing bad has happened so far, but we want to make sure that they have the additional due process protections of the UPHPA. So trying to make sure that we're protecting people before they find themselves in a very difficult situation. As far as how you can get in touch with the ULC, yeah, I'll put my email in the chat. If you are from a state that does not have the UPHPA, please get in touch with me. We will talk to our commissioners in that state. We'll try to get an effort going. But yeah, I mean, we're really trying to target anywhere that it hasn't already been passed. And sometimes the issue is that we don't necessarily have those personal stories from people, especially in those upper Midwestern states. So states like Minnesota, South Dakota, North Dakota. There's a perception, I think, that it does only affect Black Americans in poorer rural states. And so, that's obviously not true, right? Heirs property is being created every minute of every day when people are dying, either without a will, or like JC said, with a will that only is very straightforward in the way the property is being transferred. So you have to try to not create heirs property in most situations. So this is not just an issue that affects one specific demographic. And to that end, we've seen success with both Democratic and Republican sponsors. We'll get a little bit more into that later, but I think that there are genuine ways to represent this bill that look at it through various political angles, and none of those angles are incorrect or a disingenuous representation. It really does have all of these different aspects to it. Regarding this question about North Carolina, yes, there is an effort in North Carolina. We are really trying to get it passed. I think it's quite clear that it's an issue in North Carolina. We did have an introduction in 2023 and in 2024. Those efforts were not successful. So yeah, please get in touch with me if you are in North Carolina, if you want to get involved. We absolutely need folks who are involved in these issues and who are willing to help us provide testimony, even if it's written testimony, virtual testimony. All of those things are available, and we really appreciate the help.
Yeah, one of the follow-up questions I was going to ask you, and this is an example of this, is in North Carolina. What are the politics of it? Little p, like who are the opposers and who are the opposers? And I know in North Carolina, the clerks play a particular role in partition actions, and JC actually spoke to them, I think. But what does that look like in North Carolina? Is a great example of this.
Yeah, so the clerks, I mean, I am somewhat sympathetic to the clerks' concerns to a certain extent, because they are concerned about having to learn this new procedure. And I think that's a concern that we hear from a lot of states. To that, we would say we're willing to expand the act for states, Virginia, Maryland, DC, as a territory, obviously, but DC and California, they've all expanded the UPHPA to apply to all partition actions in the state. So instead of having what JC was referring to, where there's like an old statute and a new statute, there would just be one partition statute that would apply whether you own property as tenants in common or not. So in North Carolina, we're considering taking that angle, because then there aren't two procedures that the clerks would need to learn. There would just be one new procedure that would apply, and they don't have to do the analysis of whether the parcel is heirs property. If it's property owned as tenants in common, you're just going to follow this new partition procedure. So I think that opposition is understandable, and we are absolutely willing to come to the table and do training and try to make it as straightforward as it can be for the clerks there. I think some of the other opposition we see is, quite frankly, from folks who are profiting under the current system and who are benefiting off of a system that allows people's land to be taken, for very cheap and kind of under cover of night. And so That sometimes comes up as a variety of disingenuous arguments against the UPHPA. It's often not the case that people are saying, I like the current system because I profit from it, right? But we try to identify those arguments, those disingenuous arguments, as quickly as we can, and you know, address them as concretely as possible, and demonstrate that this act really is just designed to provide due process protections to a very vulnerable group of people. It doesn't say that they can't transfer their interest. It doesn't say that they can't sell their property to a developer, but it makes sure that they have the opportunity to keep it within the family whenever possible. And when they can't keep the property within the family, that they at least get fair market value for their asset. It's really ensuring that what happens is just.
Mm-hmm. If I could just add just really quickly, and I thank you so much, Jane, for sharing that. I think it's, it's important to recognize our system has not been a level playing field. And when I was talking about the Heirs Property Act, and we were trying to get it passed in Arkansas, part of what I said was this helps level the playing field, right? It helps families who want to keep their land, give them a fighting chance to actually do so. I think it's a really, really important factor. And just to emphasize, I was trying to get this passed in Arkansas. I went to someone who I thought was going to be supportive, and he told me that morning as we were sitting down to tea to talk about this, how he was, scouring the obituaries to identify people who had passed and who their heirs were, and how he could go find them and find the most distant ones who might not be, as tied to the properties that he was interested in. And he was very kind, but he clearly was not somebody who was going to be supportive of this work for exactly the reasons that you indicate. So I think that is very much real, and I just would encourage folks, as you're thinking about building a strategy, to be thoughtful about what the act actually does is level that playing field, not give an advantage, but really level the playing field. And you are going to find folks who aren't supportive, and you have to kind of dig sometimes to figure out why.
One of the constituencies that have been in coalition with folks who are trying to pass the act is conservation professionals. So in Florida, for example, I think it was the Defenders of Wildlife and some other conservation folks. So I think people have been pretty creative in building coalitions that include different types of people to represent their constituencies and put pressure on the legislatures.
Can I add something too, Fran? Mm-hmm. One thing that was interesting about North Carolina in my conversations with the clerks was they did feel like it was going to be a very laborious task to meet the very strict deadlines and like requirements of the UPHPA, because the whole purpose is to protect due process for heirs and family members, to make sure that this land isn't being swept up from under them. It does require like some extra steps and deadlines. But one thing that I noted that I think was received well was that here in Alabama, our judges ain't drafting their own orders. And so their clerks, I said, listen, you can put a requirement on your attorneys, the litigators, to draft proposed orders, to, make sure deadlines are met. Like it's, if the clerk or the judge is required to submit a notice to all parties, it's okay to require that the attorneys on the case prepare those orders. And so they were like, oh yeah, we could put that requirement on them. And so there were some of these things that like, there's ways to get around this, but part of what North Carolina's concerns are why I think Alabama did not roll out the act after it had been passed, was that they weren't willing to really educate themselves on what the act actually required in practice, like practically. And so I think that with all of you like becoming more knowledgeable that it's out there and that it protects, not just heirs, but also ensures that, hey, if the heirs don't take their first bite of the apple or they can't get a partition in kind, the property probably will get sold, and whatever needs to happen is going to happen. But just understanding that this law works. It has worked in states where it has been used and where it has passed. So we all just have to keep communicating with these other states that haven't passed it and showing them that it works and that there are workarounds and there are ways to help the judges and clerks navigate and learn about the act.
Yep. JC, I just want to follow up on a question in the chat from Michelle. when you say they buy out those who ask and the litigation is closed, but it's still heirs property, does that mean that none of the heirs can ask for buyout in the future?
So once it returns back to heirs property, anybody can file a partition action after that, and anybody can sell after that. But I will say this, families who go through partition litigation, first of all, it ain't easy. So it's an expensive and strenuous and long process, right? I often will tell people at the hearing, like when I'm sitting there with all the heirs back there, including the ones that wanted to sell, next time, how about y'all just go to my clients and ask them if they want to buy your interest? You know, like all you other ones that have been quiet, next time, if you decide you want to sell, how about you just give them a call, write them a letter, tell, you know, and make them an offer. It's okay to negotiate. You don't have to file the litigation just because an attorney is probably pushing you because they want those 10% sale proceeds here in Alabama to file the litigation. And I will say this, like on several of them where we did the buyout and we got it dismissed, afterward, family members started communicating with my clients and saying, hey, listen, I missed my shot to be bought out in the litigation, but like, will you buy out my interest? Now, because see, here's the thing, you come out of litigation knowing what fractional interest everybody owns. You also come out with a valuation of what the property is worth. So now you are in a position coming out of a dismissal to actually start negotiating with your family. Whereas most heirs property owners, they have not had title run to know what fractional interest everybody owns. Like they don't really know that. So usually after the dismissal, we start working on intra-family buyouts and negotiations outside of court, the way it should be. So that's kind of the process or how it's been working.
Can you say more? Those of us in the weeds know what fractional interest means, but say more about what that is.
Yeah, so as Fran mentioned in the beginning, when you own heirs property, you don't, let's say you have 100 acres and you have 4 heirs. The heir will usually come to me and say, hey, I own 25 acres. And I'm like, no, you don't. You own a 1/4 undivided interest of 100 acres, because who's to say that you own the 25 acres by the gully or the 25 acres by the road? And they're like, oh, and I'm like, yes, it's not been physically divided. So that's what fractionated interest is, or fractional interest. You'll hear sometimes percentage interest, 25% or 1/4. Heirs property is owned in some type of fractional or percentage interest of all of the land. And so that's what I mean when I say fractional interest. And it's based on value. So if I know the value is $100,000 and you own a 1/4 interest of $100,000 property, what is your interest worth? $25,000. That's how we do the negotiations, typically when we're doing the buyouts. And that's what the UPHPA is based on too.
And when that person, the client who comes to you and says, I own 25% of this, when they die, and if they leave heirs property, then their kids have, if there's 2 kids, they each have 1/8 of that, right? So as it goes down the generations, there's, you know, Karama has a big family. There's a lot of small interests.
Yeah, we see like lots of 1% interests all over the place because they just get worse and worse as people die on without stopping the bleeding.
And I would just say, like, I mean, definitely in that category. I would say, you know, that is the importance of the communications, JC, that you just mentioned, right? Like, you know, ensuring that families, you know, I gave an heirs property workshop recently and folks are like, what can we do? Is the first thing you can do is create a family tree, like really sit down and create a family tree. And, you know, be clear, not just who is in the family, who are the descendants of the person who bought the land, but how can you find them, right? Because it's one thing to know that cousin so-and-so had 2 kids. Do you know their names? Do you know their address? Is it more than just you can find them on Facebook? Do you have something where if you needed to send them something, they could get it and sign it and return it back to you, right? All of those kinds of things. So that is something that is so important. And it's those relationships, JC, that you were talking about that are so critical in being able to do that. I have numerous people where I think, I know how many kids they had. I know one was a boy and one was a girl, but I don't know where they are. I don't know how to find them. I don't know their names, right? And so, you know, that kind of thing is really, really important. So if, you know, if any of you are in a position where you're working, or if you have property yourself, or you're in a position where you're working with families that do, that is a critical first step.
I totally agree. In fact, I won't take a case until you provide me with the family tree with all dates of death. So like I require that the client or the potential client do that homework on the front end, because I've got to do a title opinion before I can ever begin resolving any heirs property. The family tree is number one, the first step.
Mm-hmm. There's a question, JC, in the chat. What happens if an heir wants to buy an interest of someone who actually owns the land, but they don't own a fractional interest yet because your parents are still alive?
I think what she's referring to is if they're not an heir yet. So that's an important distinction, because if my mom is alive and she is the heir, I am not an heir because my mom's still alive. I'm not an heir until my mom dies. And so I would not recommend buying out any interest of someone who's not yet an heir, because what if my mom has a will that disinherits me? So now you've just paid this money to somebody that's not going to get the property anyway. But I will say this, I have been brainstorming the idea of, and I'm not like recommending this, but I've been brainstorming the idea of entering into contracts or agreements with future potential heirs that if they were to become an heir, that maybe they could sell an interest at that point. And the reason I've been brainstorming that idea, and I haven't thought it through completely yet, but is because so many elders are hesitant to resolve the heirs property, just from what I've seen. And this is living in like still Jim Crow, Alabama. Okay, let's just be real. Like the elders are still, they lived through Jim Crow. They are beat down mentally, a lot of them, and they are kind of just like, please leave me alone. Like, I don't want to deal with this. I just want to move on and get to Jesus. Okay. And so sometimes like the Gen X generation, they're more receptive to like, okay, well, look, when mama dies, like we're going to get this resolved. You know what I'm saying? So, but yeah, if you're not an heir yet, I wouldn't recommend doing any negotiations with someone that's not an heir yet.
But JC, to clarify, they would be able to. I mean, anyone can buy out, anyone can be the individual who buys out that share. Those shares are still the heirs to convey as they wish. But JC is just saying that she would not recommend it because it just complicates.
I wouldn't recommend it at all. But we do see it sometimes when people are trying to like, and this is not about adverse possession, but like we do see it in situations of adverse possession where someone's like, hey, just give me a quitclaim deed. Like, I know you don't own it yet, but you know, like go ahead and do it. And you're so right. It just complicates things so much. And I don't necessarily recommend it.
Thanks for the questions, you all. I guess one question that came up as we were talking amongst the panel was if it would be helpful to the audience for us to talk about ways that the UPHPA the Uniform Act doesn't really address some of the issues that come up, and what other things can be useful to heirs owners besides the Uniform Act. And I think one answer to that, for example, is what JC was talking about, create a will that doesn't create heirs property. But other thoughts about that, panelists? Karam, I think you had some ideas about this.
I did, but I saw Jane come off first. Jane, if you want to kick it off, feel free to.
I'll make my very, very brief pitch about transfer on death and then kick it over to you, Karama. So transfer on death deeds, we have another uniform act called the Uniform Real Property Transfer on Death Act. This has been pretty successful, like the UPHPA. It's been passed in about half the states, or about half the states allow transfer on death deeds for real property. So this allows people to transfer their real property only at the time of their death. So there's no rights to the beneficiaries have no rights to the property before they die. Once the property owner dies, the property is transferred to designated beneficiaries. They can transfer it in other forms other than tenancy in common. So they can transfer it as joint tenants. They can divide up the property. They have other options that they do not have if they just die without a will. So transfer on death is sort of our answer to preventing heirs property from happening in the first place. So if you're interested in that, again, please get in touch with me. We can talk more about it offline, but we're looking to have a push to get that act passed in more southern states in the coming sessions to try to make a very clean, straightforward, cheap way for people to convey their property outside of probate.
Thank you, Jane. That's exactly where I was going to go. And two things I'll add on that. One is that, depending on what state you're in, transfer on death deeds can be called different things. I believe in Arkansas they're called beneficiary deeds. So I would just say, like, depending on where you are, like, ask around to see, make sure you're thinking about the same thing. They're not always called TODDs. The other thing I would say is, too, my understanding is, at least in some states, the transfer on death deed can also be used to convey an interest, right? So that can be an important tool, especially if you have a large family, that is a large set of co-tenants, to begin to try to consolidate that interest. It may be that you say, I'm going to convey my interest not to all of my 3 kids, but just to one child, right? And you can do that in some states through a transfer on death deed. So again, or maybe to a sibling who already has an interest, right? So you're consolidating the number of co-tenants even more. So that's something to be thoughtful about too. The other thing I would say, as we think about, things that complement the UPHPA, is really thinking about when we talked, when Fran gave her introduction to heirs property, she talked about some of the kinds of concerns that it raises, why it's problematic, right? You can't use it as collateral. You can't, like, it's difficult to, can't borrow against it. You can't, get a mortgage. Like, all those kinds of things can be really challenging when you don't have clear title, meaning your name, or the person who's using the property, their name is on the title. There are some policy kinds of things that can be done to address some of that. And the example I like to share is one, if you think about FEMA, certainly after Hurricane Katrina, we saw a lot of interest in this, right? A lot of families had damage to their property. A lot of those properties were heirs properties. Folks would apply to FEMA for support, disaster support. They couldn't show that they owned the property because their name wasn't on the deed, right? And so FEMA at that point had fairly strict rules around that. And a lot of those families, were not able to receive support, even though they had been living in the property, for common purposes, everybody knew it was their property, but they could not show that ownership. FEMA has since changed those rules. There's probably need to do similar kinds of changes at state levels for state disaster assistance, for other types of federal assistance. So as we think about policies broadly, I would say thinking about, what are the ways that people who own the heirs property, how can they still receive some level of benefit from it? And some of the disaster pieces are a part of that. The other thing I would say, again, just to complement the kinds of things that we're thinking about in terms of UPHPA, for many families, particularly if they have maybe a residence, or if they have agriculture or timber property or that kind of thing, they may be in a position where they want to manage that property either directly or indirectly after they get the title clear, right? And so having the kinds of financing and other kinds of options that allow them, particularly if it's a family that wants to retain some type of collective ownership, if they want to then be able to manage that property, are there financing options? Are there policies and laws in the books that allow and facilitate collective ownership? So that those families, some of whom, like mine, have been around for a long time, there's no one person who we feel like is more entitled to the property than others at this point, right? And so I think collective ownership for a lot of families is where they want to go, and thinking about the rules and regs that are in place, or that could be modified or amended or put in place to facilitate that kind of collective ownership, can be really beneficial as we think about folks' ability to build wealth, build their assets, and really benefit from it.
Great. I'm just being conscious of time. It's 1 o'clock. Heather, Joy, should we wrap?
Yeah, I think, we appreciate this has been a wonderful conversation, and it's just has built up more questions in my mind that I know that I can't get to today. So I will be reaching out to some of you, and we do appreciate your time. And I want to open it up, though, just to see if anybody has like any last minute questions that if they want to unmute rather than putting them in the chat. I do want to give people that opportunity here just in the last minute or two.
And I'm so sorry, I do need to run to another meeting. So if you have any questions for me specifically, please send me an email. Thank you all so much. This was really lovely, JC.
Great.
Thank you.
Thank you. Thank you. I'm just checking to see if Heather has any last minute. I wonder if I don't even know if I can take you guys off a spotlight because
get that. So yeah, if you guys want to ask questions, if the presenters are here and able to stay on longer, we'll just kind of continue with the conversation maybe for 5 or 6 more minutes. Make sure everybody gets their questions asked and answered. And then if you come up with something later and you can't find any of our panel participants, shoot IFTN or me or Joy an email, and we can sure get you their contact info so that you can find all the answers as we run through. So I did put a link in the chat for those of you that want credit for your CEUs through IFTN. Make sure you click on that link and fill out the survey so that we get you recorded, so that you get your credits for participating in this hour. Otherwise, thank you very much to our presenters. This was an excellent presentation, tons of information, and a million resources, I think, available to everybody as we go through as well. So thank you very much.
Great.
Thank y'all so much.
Thank y'all so much. I had a quick question. This is Rachel from Virginia. Hey, JC and Fran. Loved seeing y'all in Texas last year. I was wondering, since your awesome group that does those trainings across the country, do you all have any collaboration, or are there other groups that are working maybe with Jane to work on different policies? And maybe Karama, you've been in touch maybe at your state level, but also just nationally to kind of bounce ideas off of.
We do have the organization that sponsors the training is the Southern Rural Development Center, along with Alcorn State, the Policy Center. And SRDC has a legal and policy group that meets monthly that talks about policy. So if anybody is interested in joining that, or, talking about policy in any way, you want to come for one time and talk about UPHPA in your state, or how the Farm Bill is impacting, or your local FSA office is not giving your heirs property owner that you work with a farm number, even though they're coming up with the documentation that USDA says is going to work. Anything, email me and I will include you in that group. Happy to do that. Thanks,
Fran. I will.
I have a quick question too, and maybe directed to JC, but I'm not sure. Somebody mentioned about like sometimes the barrier might be that the clerks don't want to change or don't want to. Do you guys do any like education, do any sort of programs in statewide for any of that? I mean, I'm just thinking about, for us in extension, we can't be advocates, but we can be educators. So if they're like the formats that we can help build the case is what I'm trying to think through, is how I can do it in my state without being an advocate.
Yeah. So Alabama should have done that years ago. And so really the way it's supposed to work is that the state bar is supposed to roll out that education. Okay. They didn't. And so now it's like, okay, I guess I will. But I will say this, like, we need to start teaming up more with organizations to like get this education out. And so I would recommend that you do reach out to your state bar at their website, or maybe like the head of their CLE department, continuing legal education department, and also find an attorney in your state that may want to like kind of do some of this stuff, and see if you can get them like tacked on to recommend that their state bar do some education, because it really should be the state bar that is filling that advocate gap, right? So that you're feeling like, okay, I'm comfortable doing this if I'm teaming up with somebody. Because that's kind of what we're doing here in Alabama. Like Alabama, we have, the Alabama Heirs Property Alliance that has Tuskegee, Auburn, and Alabama A&M, and all these trainers that were at the training that you attended with SRDC. And so we're like teaming up to do this education for legal professionals. Like, and those extension professionals are not legal professionals, but they're still doing the training with me, because it's so much of this is beyond just like the legal part of it, right? Like so much of it is social justice, so much of it is rural sociology for us. Some of it is financial and economic, and
for us it's family dynamics, there's all
100%. I mean, our SRDC training, as you saw, like has a whole section just on family dynamics and conflict resolution. And it is necessary. I always say that heirs property work is like some parts legal advocacy, some parts policy, and some parts social work. Like a good part social work.
Yeah.
So yeah, I
feel
recommend teaming up with your state bar and like kind of coordinating with them to get those legal professionals and clerks and judges kind of hip and educated.
Okay, great. Thank
The
you.
other thing I would add to that, it's a really excellent question, is, you know, in addition to sort of thinking about like continuing legal education after the act is passed so that people are actually aware and know how to use it and that kind of thing, but also thinking about heirs property education in general, right? How do you help people do that family tree? How do you help them recognize that if you're hearing heirs property, that actually is you, and you just call it family land, but it's you you have heirs property, right? So that people understand and they see themselves in it, so that when the advocates, if it's not you, when the advocates are passing it, they know that they're talking about them, right? And they see themselves in that work. And I think the other piece, as I said earlier, is to just really be intentional about the breadth of impact around heirs property, right? It is not just rural Southern Black folks. It is so much broader than that. And yes, it's, you know, you definitely find a prevalence of it in certain communities, but it does not mean that this act, if it were passed, is not going to benefit so many people. And so really being intentional about the types of families, large and small and old and new, and the types of properties, whether they're rural or urban or agricultural or residential or both, or mineral rights or timber or ag, like there's just a lot of variety there. And really, I think that can help pull a big net in so that you have people who can tell the stories that Jane was talking about earlier, right? Who are positioned to tell those stories because now they understand they understand that they have a role in this.
Yeah. I would just add finally, in New York State, they passed the UPHPA, and there's some really strong advocates there, and they got some press about some really horrific speculators who were doing horrible things to homeowners in New York City. You know, folks who lived in their brownstone buildings for decades and who people filed false deeds and just all this really bad stuff. And they got some good press and they got the bill passed. And then they also got enhancements to the bill passed. But they did a lot of training. And I don't know the specifics, but I could easily find out of where the money came from to do the trainings. But they had the Bar Association do the trainings of clerks and judges in New York City. And so depending on your state, it's already set up in some way for there to be education. As JC said, in Alabama, the Bar Association does it. This was the Bar Justice Foundation in New York City. So it's really, Joy, I think finding the people who know that stuff and connecting with them and finding out how it works in Wisconsin or wherever else other folks are.
Great, thank you.
Since the questions have kind of slowed down in the chat, we'll make that call for one or two more questions if you have them that you want to get answered. And again, really a huge shout out to our panel. That was a great breadth of information. So
all right.
Last call for questions. Otherwise, Fran, do you have any take-home messages that you wanted as the panel leader here to send everybody home with?
Thank you for having us. And I think there's more heirs property out there than people know, because as Karama and others have said, it's just called something different in different families. Like my friend in Missouri was not calling it heirs property. You know, just other people call it inherited land. I just did a Massachusetts fact sheet. That's what they call it there. So I think you have to dig a little bit. And I think those stories are really important. And, you know, family dynamics are rough, no matter who you are. So everybody's got the stories about the transfers and needing to be really clear about who gets what. So I would just add that. And if anybody has any questions, really, all of us are available. We're all down for helping support these folks and these families and changing policy to be more just.
Excellent. Okay. Well, my auctioneer friends have to ask it 3 times. Any other questions? Any other questions? All right, last call for questions. Otherwise, thank you all again so much. We appreciate it. If you need a CEU credits for IFTN from this session, please go find the link in the chat and fill those out. You've got email addresses for me and IFTN somewhere in your emails, everybody. So if you have questions later on, let us know and we will send those on to the right people. So. Thank you all,
Thank you
and
so much.
have a great rest of this July day, whether you're getting cooked out or rained out or droughted out, because it seems like we're doing a little bit of all of that this year across the nation.
All right. Bye, y'all.
Thanks, y'all.
Thank
Bye.
you all.